A fiery debate erupted in the Senate Blue Ribbon investigation when two powerhouse lawyers, Justice Secretary Boying Remulla and Senator Rodante Marcoleta, clashed head-on over the meaning of protection, privilege, and justice. The atmosphere was charged.
Pwede ba yung ganito?
I respect your opinion, sir. But
It is not my opinion, it is in the law, Mr. Secretary.
Yes, sir. Yes, sir. But I am
The
operating.
arbiter
Sir,
is
can I
the
speak,
law.
sir? May I speak, sir?
Yes, you are
I'm operating.
Remulla, steady and firm, drew a clear line. Bago ka humingi ng proteksyon sa gobyerno, ibalik mo muna ang perang ninakaw mo.
Hindi lang po batas na nagdidictate dito. It's also what is morally right, what is expected of us. Yan po kasi kahit hindi nilagay sa batas, mga given po yan sa ating lipunan. This is a crime against the
Mr. Secretary.
financial status of the Filipino people. What is the reason behind the law? So that we can get justice, and justice can only be attained if there is restitution.
For him, the Witness Protection Program under Republic Act 6981 is not a shelter that anyone may demand, but a privilege extended only to those who demonstrate good faith. In his words, and in his stance, protection must come with responsibility. Marcoleta, sharp and unrelying, countered only the courts can order restitution. The Department of Justice has no authority to make that condition.
That you may proceed
Ikaw ang
with what you
nagbibigay
wish.
ng opinion, nilalagay mo yung restitution to test the goodwill of a possible applicant. It is not in the law. Unless you are able to point out the provision of law that it come before. Hindi ganun eh. Sabi mo na nga, and we admitted, impliedly instituted ang civil liability, but this will come eventually after the court has pronounced kung magkano ibabalik niya kung meron man. Not before.
His argument warned against overreach, that in imposing restitution, the department risks performing the function of the judiciary. This unfolded a clash of legal titans. Remulla relied on Section 3 of RA 6981, which gives the Department of Justice Secretary discretion to admit witnesses, guided by the offense, the risk, and such other appropriate considerations. Marcoleta, in turn, cautioned that discretion, if unchecked, may slip into abuse. Yet, weighing the two, the law is clear. Admission into the Witness Protection Program is discretionary, not automatic. That wide latitude is given to the Secretary of Justice, and it is only right. Before asking for the shield of government protection, one must first show accountability. And if the department were to demand restitution so excessive as to be unfair, the remedy is not out of reach. The applicant can always go to the courts for proper determination. The system of checks and balances remains intact. In the end, Remulla's position stands stronger. Protection is not a right, it is a privilege, and every privilege comes with a price. Another day, another Regal POV.